Okay, the next topic would be what will be the consequence if there is dismissal. First, if the dismissal is valid and the ground is just cause, then there is no obligation on the part of the employer under the law to pay separation pay, unless the principle of discerning compassion doctrine applies. If there is valid dismissal as regards authorized causes, then there will be an obligation of the employer to give separation pay, the amount of which varies. If it is redundancy and installation of labor-saving device, it will be 1 month or 1 month for every year of service, whichever is higher. If it is retrenchment to prevent losses, further losses, and closure not due to business reverses, the amount is 1 month or 1/2 month for every year of service, whichever is higher. In case of closure due to bankruptcy or business reverses, there shall be no obligation to give separation pay. As I have discussed in my previous discussion, that in this case the employer cannot be compelled to pay when it is not in the position to do so, without of course prejudice to the requirement of notices. Those are the differences when you talk of dismissal. However, that was dismissal based on just or authorized causes. That was a dismissal where it is valid. There's a valid ground and there's observance of due process, so no obligation. We are now going to discuss the consequence if the dismissal is illegal, which means that it's either when you talk of just cause, there is no valid ground, and in authorized cause, there is no valid ground. So the first consequence would be reinstatement. What is the nature of reinstatement? In the case of Banyares vs. Tobacco Women's Transport Service Cooperative, April 1, 2013, reinstatement is defined as the means, or it means that the admission of an employee back to work prevailing prior to his dismissal, restoration to a state of position from which one had been removed or separated, which presupposes that there shall be no diminution in rank or diminution of salary, benefits, and other privileges. If the position previously occupied no longer exists, then the restoration shall be to a substantially equivalent position in terms of salary, benefits, and other privileges. The next question is, does this order require a writ of execution? The Supreme Court ruled that it is not necessary because the nature of reinstatement as provided under Article 294 is immediately executory. The law is very clear under second sentence of 294 that when an employee is unjustly dismissed from work, he or she shall be entitled to reinstatement. Now let's look at the reason why reinstatement is immediately executory. Now, the first is what I have discussed under 294, the law itself as interpreted by the Supreme Court. The second is the rules, the NLRC rules of procedure under Section 9, Rule 9 that was cited by the Supreme Court in the case of Incote Philippines Incorporated versus Quijada et al., April 10, 2019. And another explanation would be that it is the policy of the state to preserve the right of a working man against the consequences of illegal dismissal. This expresses the sympathy of the state and to underscore the primacy of the labor force as the prime mover of our economy. And thirdly, the Supreme Court also used the logic, citing of course the reality that if you need to file a motion for writ of execution, it will be delayed by postponement or strategies of lawyers. And with that, the working man will be deprived of wages. So those are the reasons advanced by the Supreme Court why reinstatement is immediately executory. In fact, under the rules, the employer or the NLRC rules, the employer is given 10 days to report to the labor arbiter as to the status of the implementation of the reinstatement order. Should the employer refuse to reinstate the employer on payroll or actual, the employer may be cited for indirect contempt and the employer will be liable to pay back wages. Another very important ruling of the Supreme Court is when it comes to a situation where the employee has been reinstated either payroll or actual, but the decision involving reinstatement is reversed on appeal. So this is what we call the no refund doctrine, because the employer will normally question and ask for refund, especially if the decision is reversed on appeal. According to the Supreme Court, in overturning the Genuino ruling, the argument of the employer that it would constitute unjust enrichment will not prevail, because what is involved here is a social legislation. So if there is conflict between civil code principle and unjust enrichment and social legislation, the social legislation will prevail. Another argument according to Supreme Court is if we allow that one, if we allow the employer to get refund, it would circumvent directly or even contradicts directly to the prescription that the posting of a ban or cash ban by the employer shall not stay the execution of reinstatement. In this case, since the employer has been paying the employee through payroll or actual reinstatement, and if you allow the employer to get refund, so it is like the employer who is allowed to get the cash ban and stay the execution of reinstatement. So according to Supreme Court, that would go against that principle. Now, if you will be asked regarding the difference between reinstatement and back wages, when you are asked of reinstatement, it merely refers to the order of the labor arbiter to put back the employee to his or her previous position without loss of seniority rights, salaries, and other benefits. On the other hand, when you talk of back wages, we are talking here of wages that the employee should be entitled from the time it was withheld up to the compliance of reinstatement. So if reinstatement is not followed, then the employer will be liable to pay back wages from the time the order of reinstatement was issued up to the finality of the decision. So in this case, this will be a back wages because of non-compliance of reinstatement order. However, we have to emphasize again, is there an instance when reinstatement is not possible? According to Supreme Court, the most popular cause would be strained relation. However, the Supreme Court has been consistent that the strained relation cannot be merely alleged in the complaint or in the position paper. It should be proven by substantial evidence. The mere filing of an illegal dismissal case will not lead to strained relation, even the filing of unfair labor practice. The parties have to prove that indeed there is an impact on the relation of the parties that would render nugatory the reinstatement order. Another instance when reinstatement would not be possible is when the employee is already deceased when the order was issued, or after a long period of time, or the passage of a long period of time, or when the employee has already become incapacitated, or physically or totally or partially incapacitated. Those are the instances when reinstatement may not be possible. And as an option under the law, the employer shall give separation pay. I mentioned earlier that there are instances when the reinstatement order may not be implemented. Well, let's look at an example of a teacher who was illegally dismissed, but the order of reinstatement came in the middle of the semester. So with that, there's already a teacher who was hired to replace. So the order of reinstatement may longer be feasible. Also, when the reinstatement would not serve the best interest of the parties involved. Like, for example, if the employee, the kind of conflict between the employer and the employee is too severe that forcing the parties to work together would be detrimental to the interests of the parties, especially it involves sensitive responsibilities and positions. So those are the instances when a reinstatement order may not be implemented. The most famous one is strained relation. Is it possible that there could be reinstatement with no back wages? Well, the Supreme Court ruled in the case of HSY Marketing Company versus Williams Sticky. In this case, the Supreme Court observed that both parties are in pari delicto, which means that there is no proof that the employee committed abandonment, and same time there is also absence of any showing of an overt or positive act proving that the petitioner had dismissed the employee. So there was this decision which balanced the interests of both employer and the employee. So in that case, there is no reinstatement and no back wages at the same time. This scenario was again reiterated by the Supreme Court in the case of Rodriguez versus Syntron Systems Incorporated, July 24, 2019. there is also a case of reinstatement where there is limited back wages. I am looking at the case of Victory Liner Incorporated versus Pablo Rasi, December 8, 2008. In this case, the Supreme Court ruled that in case the employee is illegally dismissed and was ordered reinstated, but the employer was in good faith in terminating the employee based on its health, welfare, and retirement plan, the award of back wages was limited only to 1 year, considering the mitigating circumstance of good faith attributed to the employer.